We break. Keep going.
Sure, thank you.
Okay. Next case on the docket, TT of Indian River versus Heidi Fortson.
Your Honors, I'll have 15 in my main and 5 in rebuttal. This was a trial with multiple errors in the trial court, and the result was the verdict was $4.35 million reduced to $3.6. There were several clear errors under Florida law. Several of them related to the fact that the plaintiff did not testify at trial, and they presented 3 hearsay letters from the doctors. We moved for an evidentiary hearing.
Did you subpoena
the
the plaintiff, counsel?
Pardon me?
Did you attempt to subpoena the plaintiff?
Did we attempt to what?
Subpoena the plaintiff?
Subpoena the doctors?
The plaintiff.
We found out the day of trial that she was not going to be there, and the judge said, well, you can subpoena her to come. We said, Judge, she's in. First of all, this is trial by ambush. We weren't told but to the day. But secondly, she's staying in a hotel somewhere. We can't find her. And the court has the power to order people to attend, order witnesses to attend or parties to attend.
Didn't the trial court say that if you had trouble serving her to let the court know?
I don't believe so. He just said you can serve her, and we said we're not able to. I mean, we don't know where she is. She's in a different town and in a hotel somewhere.
I believe I'll go back and check it, but I believe that's in the record.
We asked the plaintiff to accept service, and they wouldn't accept service.
I believe I'll go back and check, but I believe that is in the record that the trial court told you to come back and let the court know if you were unable to serve her with a subpoena. Did you ever attempt?
I believe you might have, but I think during trial I believe that is correct. He said we could. There were just multiple errors that were happening ongoing, and we think it was error. I mean, for the judge not to order the plaintiff.
Did you ever go back to the trial court during the trial and tell the trial judge that you were unable to serve the plaintiff with a subpoena?
I don't recall that he did return and tell them that. I'm not sure. I'll check and also be in touch. But the letters were clear hearsay.
Are you confident that that hearsay objection was made at trial?
I'm sorry?
When the letters were presented, are you confident that the hearsay objection was made? Specifically hearsay.
Am I confident that we made a hearsay objection?
Was it adequately preserved?
We asked. I don't think we used the word hearsay. We asked for an evidentiary hearing on the letters, which is equivalent to that, and we're entitled to it because otherwise they are hearsay. We asked for an evidentiary hearing,
at some point let's go get off of this at some point, because it just seems that you never preserved it by objecting based upon hearsay, and in terms of her not being present, there's nothing in this record that you all made any efforts to serve her. But let's talk about the other issues that you've raised.
I'm sorry. I've got an ear infection in my right ear. I'm operating on one ear. I apologize, Your Honor.
Let's move on to some of the other issues that you've raised.
Yeah, but beside once again and then not only did they were able to tell the jury that in voir dire that the judge had excused the juror because he determined that her health was too frail, it'd be harmful to her health to attend at trial. And that's, once again, clearly improper because that's not based on any evidence at trial. Then during trial, we could not comment that there's an inverse inference because she wasn't present. They said, well, if they give an excuse, you can't do that. There was no evidence at trial that gave an excuse. There was no evidence as to why she went there.
Talk about the testimony of the corporate representative.
Yes, Your Honor. That was clearly improper. We admitted liability, And if you admit liability, the law is clear that you're not supposed to introduce evidence that of liability and things that inflame the jury. And all the questions there on page 45 and 46 of our brief were just clearly to inflame the jury.
Well, one of the comments,
Mercedes-Benz admit guilt.
counsel, one of the comments related, at least one of them related to whether the crash was a violent crash. Is that correct?
One of them did, Your Honor, yes.
And wasn't that relevant? Didn't one of your experts say that that was a relevant consideration?
Well, I think that one question may have been the only one that was, but all these others, was it, did they admit guilt? Did they just admit guilt last week? We heard that Mercedes-Benz is making up her injuries. You didn't do any investigation at all in this crash. Why didn't you report to anyone at Mercedes-Benz? All these, do you know last week was the first time Mercedes-Benz admitted guilt? These are all totally improper. They just are totally liability to inflame the jury with no relevance to damages. So it's respectfully, that's a clearly error. And the once again, the Dr. Livingston, I mean, he excluded the testimony of Dr. Livingston, which is totally proper. He was testifying that the methodology used by their doctor was not proper because he didn't calibrate the MRI machine.
Was Dr. Livingston's opinions, did they comply with the pretrial order?
Well, that wasn't the reason he was excluded. We moved for an extension, and the plaintiff opposed it. When we pointed out that, then he dropped the judge, immediately dropped that part. It wasn't timely, and all of the discussion was that improper methodology.
So, and let's latch onto this point for a moment. I want to make sure I'm clear. Your position is that you disclosed that opinion by Dr. Livingston timely.
Now, I'm saying it was untimely, but we moved for an extension, and they had time, and that's not the basis on which the judge opposed it. I put all the quotes in my brief. It's very clear the judge didn't do it because he said it's improper methodology. I think.
Counselor,
in my reply, I believe there's quotes from the judge at pages 6 through 8, and the conclusion, because he's now commenting on another expert, and he's commenting on their ability to do methodology. He's run no tests. He's got no predicate to do that, so that's not coming in.
Counsel, in this context, are we limited to the trial court's reasoning for its ruling?
I'm sorry, the court's ruling what?
Are we limited to the trial court's reasoning for the ruling, or can we affirm it for other reasons?
Well, obviously the court can affirm for other reasons, but I mean the reason that the judge did all of these things is clear on the record. I mean, it's not, if there's one thing and it was all right for another reason, but when there's a whole series relating to hearsay doctors' reports and telling them, the jury, the doctor excused her for it, evidence even starts. The jury's told the doctor determined her health is very bad. And the adverse inference, that's clear law. The other one, excusing a jury on the fourth day of trial, the plaintiff comes in and says, I just discovered a DUI 25 years ago that she didn't disclose. Well, the law is clear. Even something 10 years ago is not sufficient, and 25 years ago is clearly not sufficient. And plus, where's the predicate for doing it on the fourth day of trial? That's just...
So did the judge excuse the juror?
Pardon me?
Did the judge excuse the juror?
On the fourth day of trial, the plaintiff came in on the fourth day of trial and said, I did a background check and I see this juror had a DUI 25 years ago, and we said that's too remote, and the judge excused that juror on the fourth day of trial.
The juror asked the question about whether there had been any prior...
Yeah, it was something she should have disclosed, but it's still 25 years ago, and it's the fourth day of trial. I've never heard of it.
Cases involving remoteness often deal with criminal convictions and whether they can be used to impeach. Here we have a juror who gave, at best, an incorrect response to a question, if not an untruthful response to a question. When that was determined, why can't the judge make the determination that that juror should be excused? The information given that everyone relied on day one was inaccurate.
There's a whole series of cases on how long ago it has to be, excusable. I mean, there are a line of cases, and we cited them, and generally more than 10 years it's not, and 25 years ago, and it's no similarity to this accident. And then once again, the fourth day of trial, there's no precedent for that. Oh, I want to say another thing. We wanted to make a comment to the jury on the adverse inference because the plaintiff didn't apply, and the judge said, no, I won't let you do that because you stipulated they don't have to be here. And that's totally wrong. We objected over and over and over. And so when you have a whole series of things that these improper reasons are given if, like I say, the right for the wrong reason, you see, one thing, but wait, but I mean, here you have a whole series of things where the judge is clear the reason he's doing it, and that's not, proper under the law. So we think we should be entitled to a new trial. I mean,
Counsel, was the alternate juror present for the entire trial?
The alternate juror sat and decided the case. But I mean,
Was the alternate juror present for the entire trial?
Yes, she was. But I mean, once again, when there's no reason to excuse them, and you know how trial attorneys study the jurors to see who's buying the case, and let somebody do it on the fourth day of trial gives them.
But this happens after trials are done as well. So let me ask this: did in their closing argument, did counsel for the plaintiff use the term guilt to describe the plaintiff's admission of liability?
He used it various times in trial. I know a lot when I represented. I'm not certain offhand. I'll look real quick and see if I can find if he did in closing. Because I know there's strong cases by this court that they should not use the term guilt in a civil case, and he used it, our representative, who shouldn't have been called, several times.
All right.
Thank you.
Thank you.
Good afternoon. Thank you for the opportunity to appear before you today. I appreciate it. My name is Celine Humphreys, and I represent the appellee today. I'm going to start off with the issue regarding the juror that was removed from the trial. There were a lot of questions regarding diving into the analysis of whether that person should have been removed, but really that question, that issue, is easiest answered by this court's decision, Lowry, which we cite in our brief, 2007. To your point about your questions, if it is error, we don't think it is. If it is error, it's harmless if the juror that's removed is replaced by a duly appointed or duly, it's not appointed, but selected juror. So that ends that issue. I do want to say, though, there were these aspersions regarding, we're up to no good, waiting until day 4, watching and thinking about who do we like and who do we not like, and then a gotcha.
Well, how about waiting on the first day of trial, informing them for the first time that your client wasn't going to be at the trial?
Well, first of all...
So you can kind of get the sense that perhaps they're seeing a pattern here.
Seeing a pattern, looking at that, combined with the juror?
With the fact that you all are waiting until the last second to do all of these things.
Okay. I'm going to go ahead and finish with the juror, if you don't mind, and then come back to talking about our client. So in the context of removing a juror, if you look at Florida case law as it's evolving regarding juror non-concealment, and you look around the country, what in fact the policy concern of courts is, if there's an objective, identifiable fact that you can find just by looking in the court records regarding people on your jury, and you can find that out during...
Right. That's great. I'd like to actually talk about something different, if that would be okay with you.
Absolutely. You were connecting them up, so I was letting you know this was actually a good thing by us, not
I'd
bad.
like to discuss the corporate representative.
Oh, okay.
They conceded liability, and yet the first witness you call is their corporate representative, and get to, the questions that were asked really seem to be geared towards painting the company in a negative view. That was really the purpose of it. There was only one mention of the nature of the crash. The rest of it was just, how little they did and to investigate and that type of thing. What do you have to say about that?
I have a couple things to say. First of all, and with respect, I do not think that is an accurate summary of these 8 pages of the trial transcript. And when I say 8 pages, it's even less than that. It's irrelevant. Okay.
It's not how many pages.
I'll go
it's
on.
The nature, what I'm concerned about is the nature of the questions that you all asked.
I hear you. So I'll do a better job of answering you directly, Your Honor. So to answer you, I'd say there are 2 different categories, roughly, of questions. There's the few that they actually objected to. There are 4 of them, and they all relate to accident investigation. Those are the only things.
They filed a motion in limine for the corporate representative completely, right?
Right, but
So-
the only purpose, that's something they argue in their reply when we argue, and I'm not avoiding you. I know it sounded like I started off on preservation. I'm coming back. But to answer you, that is what they said in the reply brief. Go look at their motion. What actually happened is they were arguing against the concept, period, that you can have an individual who can testify on behalf of the corporation. So all of these arguments that you're reading about in the initial brief and then seeing in the reply brief, those were not made in that one document, number one. I'm going to come back to your questions.
No, I'm going to come back to my questions.
Yes, sir.
Was this question asked? If Mercedes-Benz of Melbourne admits guilt? Guilt?
Yes.
Was that question asked?
Yes, sir, it was.
Is that an appropriate question?
No, sir. And the trial
Right.
court sustained it.
Then that's fine.
Was that question asked twice?
No.
Was there not another time when they asked the corporate representative, didn't you just admit guilt last week?
Okay, so there are a couple of questions. One is, and I have them all delineated, yes.
He asked you if it was asked more than once. You said no, and now you're acknowledging it was more than once.
I am not trying to be unresponsive, sir. When it was asked again, first of all, they asked, did you admit guilt? The court said, the defendants objected to the word guilt. It's not appropriate. The court sustained. Plaintiff immediately rephrased as negligence. The second question was, when did they admit liability? And defendants did not object to that.
They didn't use the word guilt a second time?
I do think there is a second, I don't know if it was that particular one about admitted liability. There is another time in the questioning where the word guilt is used, yes.
I'll read it to you. Even though Mercedes-Benz of Melbourne is admitting guilt for negligence, we just heard that Mercedes-Benz's defense is that Heidi Forstum is making up her injuries. Is there anything about that question that's proper? Any aspect of that question that's appropriate?
No.
You ask, that, in fact, you're only here today because we subpoenaed you. Is that correct? And so we have this full picture. You answered questions that we've relied on in this lawsuit on behalf of Mercedes-Benz when you don't work for Mercedes-Benz of Melbourne. What was the relevancy of that?
Okay, there is a portion where plaintiff's counsel actually moves for sanctions, and when I was trying to address this earlier, it was not trying to avoid your direct expressed questions. So what happened was, we sent interrogatories to the corporate defendant, asking the corporate defendant to answer questions about their investigation of the accident. Anything that they did relevant to investigating how the accident happened and how they conducted the investigation is
Irrelevant.
No, sir. I'm almost there.
Once they admit liability, you think that's relevant?
It is relevant to the extent that during discovery, we can then do better discovery on our own by learning about how they discovered. And those facts about how the accident occurred and their investigation of the accident, and I'm not just talking liability, because it ties to damages. Our experts explained that when they are, particularly the
Mercedes, the corporate representative is not going to have any testimony as it relates to damages, period. Correct?
and this is where I'm politely disagreeing with you, that representative of the corporate defendant, as the representative of what is inherently a person in the courtroom, has information regarding what they learned about how the accident, not how, that's liability, the context of it, the severity of the accident, and their
What material issue?
I'm sorry?
What material issue that was in dispute could this woman, Ms. Hernandez, have possibly properly commented on in front of the jury? Is she competent to talk about medical damages?
No,
Was she a witness to the accident?
no.
Can you tell me then, why was she called?
Your question is actually tying into, first of all, the trial court agreed with a lot of what you're saying and limited the testimony. So this was,
It didn't stop y'all because, as Judge Eisenhower pointed out, there's a third time that you also say, and isn't it true that until last week in 2016 was the first time Mercedes-Benz of Melbourne admitted guilt? So, I have the same question that, that Judge Egan has. I'm not seeing at all the relevancy of calling this witness other than for you to get a witness on the stand to make this company look bad.
I hear you. And I'm going to try to do a better job of answering both of you. So when you look at the testimony of our radiologist, that's one of our experts who talked about the scans. He makes the point that when you're talking about damages that occurred, there was a very intense battle in this trial regarding other injuries were conceded, but the severe brain trauma was the disputed issue. And so what the radiologist said is, you don't just look at scans, you don't even just look at the neurological testing, or I'll say it right, neurological psychological testing by the psychologist. You look at the facts of how the accident happened. And by that, I don't mean somebody like going out of their lane. I mean the collision part.
Isn't that better addressed by accident reconstruction experts and engineers rather than a risk manager who is counting beans? And there were indeed trained accident reconstruction experts. Again, it begs the question, why was she even called when there were other methods to get the information you're talking in? Mechanism of injury.
Right. I understand that there are other methods. That doesn't mean that she didn't have evidence confirming the
Counsel,
violence of the
that's the
accident.
problem, though. That you just hit the nail on the head,
Oh,
right?
yes.
Had you asked her, and she said, "Oh, sure, I did a thorough investigation and I have all this knowledge about the accident," then perhaps you'd have an argument. She didn't have any knowledge about the accident.
She did.
And the questions that were asked seem to be focused on the fact that she didn't do a good enough investigation. Why wouldn't she know? She should know. Why doesn't she know? Instead of, well, once you find out she doesn't know, moving on. Isn't that the where your argument sort of falls off?
My argument does fall off to the extent that there's questions about admitting guilt and when did you admit liability, and I'm not defending that. But what I started with earlier, saying I wasn't trying to avoid you.
Well, what about not reporting to anyone at the defendant? Well, what does that have to do with it?
Okay, I'll explain that. Let me finish this one clause. Everything you're asking me about was not preserved. The fact of not reporting to the defendant, when we were in trial, was the first time plaintiff's counsel understood that she did not have knowledge of this information. When the plaintiffs, that's why I was telling you about the interrogatories, when the plaintiffs sent the interrogatory to the defendant, we're in the middle of discovery. We need to know what you know about the accident. That will help us investigate our case on the damages. I'm talking about the accident to the extent the violence of it supports plaintiff's theory that it was violent enough to cause a severe brain trauma. Their theory was, no severe brain trauma. So part of what we had to do for the jury is to tell them not what led to the moment, but the moment. And we asked the defendants to give us, what do you got on that? And this is the woman they provided.
At the time of the accident, where was Ms. Hernandez?
At the time, she wasn't there. I understand. I hear your point, that she was, and frankly, Your Honor, that was the reason that the trial judge said stop. And in fact, the trial judge went further and said, I'm looking at the interrogatories, because the plaintiff then, in trial, brought a motion for sanction saying, we asked them to send the person who has this information. This is the person that they had sign the interrogatories describing what Mercedes-Benz knew about the accident as it related to...
So these questions were directed to, or really, the purpose of these was to prove up a motion for sanctions?
No, I think I'm speaking poorly. So before trial, the interrogatories were filed as part of discovery. And we want to learn what they know about the extent, the severity of the accident, because our position is the accident was so severe that the injuries were so severe. We send that to a corporate defendant. The corporate defendant says, her. And so, her is who we bring to trial. We ask her questions, on the good point you haven't gotten upset about, we ask her questions about how severe was the accident itself. Was it violent? Yes. We ask her, tell us some details about it. Did it spin out of control? You know, is there anything else you know? She has that information. She says yes. We also ask her, is there anything else you did to investigate? Anything else you can tell us? Did you look beyond the accident report? Can we have more information that you have about it's a bad accident, so bad injuries? Mm-hmm. That's all that they preserved in the trial court. So everything you're asking me about right now, one, was not preserved in the trial court, was not preserved. And number two, the trial court stopped it.
If the issue was addressed in a motion in limine and that objection was renewed, I'm struggling with is how it wasn't preserved.
Okay. So if you go back and look at the motion in limine, and you're right, there was a pretrial motion, and there are some circumstances per statute where it can be deemed sufficient enough. That dealt more with the concept of who do we identify as a corporate defendant? You can't find somebody with personal knowledge. That was the idea of, you know, they were contesting. At one point when this was argued during the trial, again, it's 8 pages, and most of that is argument. At one point, they're like, there's no such thing. You can never have a person with personal knowledge for a corporate defendant. And that was the point that they were pressing, not these other points. So I do want to go through points.
But you can see that there were multiple improper questions then during the questioning of the corporate representative. You're just relying on, your really only argument, your only defense there is that, hey, it wasn't preserved.
I think there were a couple that were to the level of improper that
there was at least 2 or 3 that where you referenced guilt.
Yes.
What about you didn't report to anyone at Mercedes-Benz?
That is why I went to explaining the sanctions. All of a sudden, she says at trial, and this is why we filed the sanctions motion, we were caught flat-footed. In trial, she says for the first time, even though she signed interrogatories for Mercedes, I don't work for Mercedes. And so we were like, well, who do you work for? So that was just following up on us being caught flat-footed at trial regarding a question.
What about the comment about the subpoena? You're only here because we subpoenaed you.
Yes.
What relevance did that have?
That was I don't think by itself, it is something that we would normally ask, except maybe arguably it relates to bias, but that was clear if she's a representative. If you look though, if you actually look at the transcript, that's all part of the 1, 2, 3 of like, who are you here? So it all tied into that.
What about the, you answer questions, but you don't work for the defendant?
That's what I was just saying. You answered.
So they were caught flat-footed, except for the problem with that defense of that is you used it in closing argument.
There was a comment.
It wasn't just that you were caught flat-footed, because I assume by the time you got to closing argument, you were no longer flat-footed, right? During closing argument, you said, you know, they bring someone who is identified as a risk management with the defendant, and she says that all she did to investigate was look at an accident report. And then we find out she didn't even work for them. What does that mean? That's what was said to the jury during closing argument. So it wasn't really just a statement made because you were flat-footed, correct?
At that point, we knew the fact. You're right. I hear you there. I will tell you, we had moved for sanctions beforehand, asking for stuff much bigger. For us to have a representative of the defendant there to be asking questions about damages and to find out that that person doesn't even work there, we were caught flat-footed at that moment. We moved for sanction. The trial court denied them.
What was the date of the trial?
I don't have the exact date with me, Your Honor.
Would you agree that whatever number of improper questions there were, they were compounded by the improper argument?
Typically, that is what would be argued, but here, that comment wasn't objected to. The whole purpose of of a preservation of error, it's not just something I argue, that appellees argue for fun. Preservation of error is not about preserving an appeal, it's about avoiding an appeal. In that moment, when that trial judge is there watching that trial, if there's an error that is so significant that it is denying you the opportunity for a fair trial, it is your obligation to go to the judge, the police officer in the courtroom, and say, hey, we need a clean trial.
Yeah, counsel, I think we understand the concept of preservation of error. Your position is that it's not preserved because the motion in limine was insufficient to do so. That's your position.
The motion in limine was not this basis. If you look at the hearing on the motion in limine, it is not the arguments that they make. And you took me through the questions, so if I can do the same. There are two questions about whether she really works for Mercedes. That's the part, I understand what you've said about closing, but that's the part during the questioning when we were caught flat-footed. The first one, whether she reported to anyone at Mercedes, there was no objection. I've been very careful about the record here. I know what I'm telling you. The second one, whether the corporate representative answered questions on behalf of a company she did not work for. The defendants objected. We didn't get an answer. We moved on. And then on top of that, defendants did not ask for a curative, did not assert a mistrial. That is significant. If it is so important that we're going to take this court's time and send a case back to a new trial, go through all of that again, and sadly have the inevitable appeal, surely it's important enough in that moment to tell the judge, oh my gosh, stop. This is bad stuff. It did not happen. And then going on to the question about the trial subpoena. That one, I do believe, was objected to. Finally, these three were not preserved. One, whether Mercedes admitted guilt. Judge Cohen, as you know, the defense argued only about that we should not use the term guilt. The trial court agreed, and we changed to the word negligence.
So they did object to that one.
They did object. I'm continuing my point. So we then withdrew the question, a la as in striking, and honored the court's ruling, and we said negligence.
Well, you said it again after that.
We did say it again, and I'm not going to defend us stepping again there, being sloppy. I'm not going to agree that we are intentionally plaintiffs' lawyers getting away with something, but I am going to say if that was an issue, and especially when a trial court had already said, yeah, that can't be said, it was their obligation to object again when that word was uttered a second time in the questioning of this witness. Then the third one is the defense position at trial on injuries. That one the trial court sustained. Now remember, an objection is not all that's necessary for preservation. If a trial court agrees with you and says, a question is wrong, I'm not going to allow it, the error has been cured. That's what an objection is all about. If you still think it's bad enough that you're going to go to an appellate court later and ask for a new trial, you need to go further and say, this is really bad right now.
All right, counsel, your time is up.
I appreciate the opportunity. Thank you.
Thank you.
Kind of respectfully, I think counsel is mistaken about our objection to that testimony of the corporate representative. On pages 11 through 13 of our reply brief, we point out 4 different times that we object to it. First of all, not only filing the motion in limine, when we argued it, mine is a motion to quash. We've stipulated a liability. She has no personal knowledge of anything other than she's a corporate. So I'd like to have the subpoena quashed unless they say what relevant evidence. That's at T21. Then at T331, she has no personal knowledge of the accident. She's looking at one picture, and it's not relevant either. We've admitted liability. All right, then at T334.
Did they refuse to tell you what the relevancy of her testimony was going to be in response to the motion in limine?
Well, he objects. Well, the last one, he's saying it's all irrelevant and ask it to be. This is nothing but, let me see. This is nothing but an attempt to make the jury angry with my client who's already admitted liability. Again, I think all of this is inappropriate, and I ask that it be stricken and not be allowed. So he's not objecting to one question. At the beginning, he said it ought to be quashed, and he's saying it all should be stricken. It's all improper. So it was clearly all objected to.
Was there a request made by the plaintiff to explain the relevancy of the corporate representative's testimony, and they declined to do so?
They did not ever give an appropriate reason why the liability testimony was appropriate, or talking about whether they're, guilty and all of that. That's correct. Now, I want to go back to Dr. Livingston's testimony. The judge, the clear reasons, once again, I gave you all those quotes, is that one witness cannot criticize another expert. However, it was the methodology. What happened is that he used an MRI without calibrating it. Our doctor says you have to calibrate it. In other words, he used the baseline for most people. However, he needs to use it for a bunch of people and get a baseline before he can even tell whether somebody else deviates. So it was based on the methodology, and clearly that's proper to use under Florida law, and the judge excluded it, so we couldn't bring in that test wasn't proper in this case. The other thing, once again, we clearly have a right to comment on an adverse inference. The reason the judge said, oh no, you stipulated she didn't have to be here. The record is so replete, we did not stipulate
Counsel, that you might not have
and
stipulated, but there was a pretty significant explanation, at least, for the plaintiff's absence, was there not?
I'm sorry?
There was a significant explanation for the plaintiff's absence from trial here, was there not?
Well, doctors' hearsay notes, letters that we didn't see to the day of trial and ask for an evidentiary
You
hearing.
can't come here and argue hearsay when you didn't argue hearsay to the trial level.
They didn't use that word, but asked for an
Well,
evidentiary hearing
that's
on it.
Let me, I'm trying to remember when I first heard that word. It might have been, well, maybe even before I went to law school, but I'm sure I heard it in law school. And I can tell you that every lawyer, if you can't come up with the specific hearsay objection, but hearsay, the basic objection, and we're a court of correction of error. How fair would it be to the trial judge if we reversed the trial judge and the trial judge never had an opportunity to rule upon that?
Well, but I mean, we did ask for an evidentiary hearing, and
Counsel,
that isn't a problem.
do you have a case, Counsel, can you cite to me a case that requires that the explanation for the plaintiff's absence be proven in an evidentiary hearing?
I'm sorry, please.
Is there a case that requires that the plaintiff's explanation for not appearing at trial, is there a case that requires that to be proven at an evidentiary hearing?
All the cases they cite are ones where it's testified to. There was no testimony that attending trial would be deleterious to her. I mean, there was none. I mean, so the cases say are all based on things that come out on the stand, not something a letter that never came in at trial, Your Honors. So, based on these abundant several reasons, and I mean. There was a lot of error at trial, and once again, cumulative error, and we respectfully submit that, especially, under the Supreme Court's new guidelines, unless they can prove the jury didn't change the result, then you get a new trial. And under all of these things, clearly, there's an inference that it could have changed the result. I mean, very likely did, and it was abundant error, and we respectfully move for a new trial. Thank you very much.
Thank you, sir.